Hello, everyone. Welcome to the fifth episode in the Rhodes to Law interview series. My name is Rahul Bajaj, and today we are joined by Douglas H. Hallward-Driemeier. Douglas is a seasoned appellate litigator in the US and has argued 17 cases before the US Supreme Court and has submitted more than 200 briefs in that court. He was a Rhodes Scholar in Oxford between 1989 and 1991, and he studied the MPhil in politics here during that period. Perhaps the highlight of his professional career so far, in his own estimation, has been the Obergefell case, in which he argued on behalf of the petitioners. He was one of the two lawyers who argued on behalf of the petitioners in the US Supreme Court, and as we all know, the court there held that same-sex couples have the right to participate in the institution of marriage on the same terms as opposite-sex couples. He served some of the other professional milestones in his career that are worth mentioning. Are that he studied law at the Harvard Law School. He then worked in the Office of the Solicitor General of the United States between 2004 and 2009. In that role, he briefed and argued cases before the US Supreme Court. And in addition to Obergefell, he's also been involved in a number of other LGBT cases, such as one holding that a same-sex spouse of a birth partner has the same parental rights as the birth parent's opposite-sex spouse, and also other cases on employment, education, etc. And in recognition of all of these contributions to the cause of substantive equality for LGBT individuals, he and his firm were given the Dan Bradley Award by the LGBTQI Bar Association. Thanks very much for joining us, Doug, if I may call you that. It's an honor to have you here today.
Wonderful to be here with you, Rahul. It's going to be a pleasure to chat with you.
Yes, thank you so much. So my first question to you is about your childhood. You grew up in St. Louis, Missouri. Can you tell us a little about your childhood and what you consider the formative moments from that period for you?
Well, I would say that in some ways I feel very fortunate in my upbringing. I had a wonderful, had a very middle class experience. So
your voice is coming through in a slightly muffled way, Douglas.
Okay, well, let me get a little bit closer.
It's good now. Now it's good. Yes.
So I was saying that in some ways I feel very fortunate that my childhood, I had a very loving family. We had a very middle class existence. So I didn't suffer from any want. In terms of the things that affected me, that I sort of see as carrying through the rest of my career. One thing I would say is that Missourians characterize themselves proudly as there's a phrase that describes stubborn as a Missouri mule, and which is not in some ways very very pleasant characterization, but we wear it proudly in the sense that I think Missourians are kind of naturally kind of a small C conservative crowd. We don't embrace change just for change's sake. We are in that sense, value to some extent tradition. So, and I think that is something that has stayed with me. But in terms of the period that I grew up in, and I suppose this is true of others of my vintage, we were really growing up in the period in which the civil rights victories of the 50s and 60s were still being worked through, right? Society was still struggling with those and struggling to live up to the promise of those decisions. And I would say that that's something that really did stick with me I remember being a young person in third, going into fourth grade, when our school district was merged with another school district, which was largely African-American students. And I remember my neighbor, who was my best friend at that time, his family moved out of our school district as a result of that. And I remember just being terribly upset that that his family had made that decision. And I recall writing a piece in school that was just a kind of a reaction piece the teacher had asked us to write. And she later asked me to share that piece with the school. And I kind of look back on that as perhaps the first time that I had vocalized my interest in civil rights and equality. And I do think that period, living through that period, was kind of fundamental to me, because I was really inspired by the civil rights movement and
Right. Okay. Sorry, I have not been able to hear you after you said the civil rights period. Did you say anything after that?
I just said that I was inspired by that, and in some ways, seeing the way in which the civil rights movement has used laws to achieve greater justice was one of the things that inspired me to want to pursue a career in law.
Right. Thank you for that very inspiring and wholesome response. My second question to you then is about your undergraduate education, which you pursued at DePaul University in Greencastle, Indiana. Can you share with us how that experience shaped, if it did, if it did have such an impact in terms of shaping your worldview and thinking, and then also what were the values that you imbibed during that period?
Well, I certainly look back fondly at my college years and the way in which it encouraged me to start thinking more critically. While I was there, I joined the Honor Scholar program, which was a multidisciplinary program that really sort of looked at questions from different and various perspectives. And I really found that intellectually very stimulating, and I've tried to bring that through to other things that I've done. But I think in terms of again, one of the things that I've looked back and I say, that was actually kind of a seminal moment. I remember a course that I had in that honors program where we read a book called Habits of the Heart by a sociologist named Robert Bellah. And he explored in that book a concept of the critical reappropriation of tradition. And as I said before, someone from Missouri, we always, embraced tradition. We were skeptical of too radical a change. And what I really liked about Bellah was that he talked about the importance of these traditions and institutions that have grown up over generations, but about the need to reevaluate them and reappropriate them and make them relevant to the present time in light of new realities. And so it's kind of the phrase, don't throw the baby out with the bathwater. And that sort of encapsulates to some extent that approach. And I think that in some ways, constitutional litigation that I've been involved with is a little bit like that, trying to really unwrap this and understand what the true essence and essential nature of the rights that we enjoy are, and how they then apply to new realities.
Right. My next question to you is about the speech that you gave in the commencement ceremony in 1989 when graduating from DePaul University. In that speech, you urged your peers to be clear-eyed idealists as opposed to being realists, and you made a very powerful case for that. My question to you is, having lived life after that for 3 decades, would you say that your experience since then has hardened your heart and made you a more hard-nosed person, more pragmatic, or do you still believe as vociferously in that idea as you did back then?
First of all, I want to congratulate you on your the depth of your research, that you found my commencement address from many years ago.
Yes.
I think I still hold to those views that I expressed in that speech. I am an idealist in the sense that I don't think we have to accept the world as it is and think that we can't change it. But I am a pragmatic idealist in the sense that I don't think that, for example, we're going to change the basic nature of the market and market economy. I think that we have to operate within the systems that exist, and so perhaps it's a little more incremental, the approach to change, rather than revolutionary.
Right. So my next set of questions are about your Rhodes years, which is the period between 1989 and 91. And the first question that I have on that front is, what were your expectations what were your expectations of what the Rhodes Scholarship would be like when you got it going in, and to what extent did the actual experience map onto those expectations?
Well, first I'll say that I felt a little bit like I had been plucked from obscurity and was being transported to kind of a different realm. Certainly Oxford was outside of my familiarity growing up in St. Louis. And in fact, I remember reading the book Great Expectations before going to Oxford, because I felt at a high level of generality some similarity to being taken and thrown into an entirely different world. The thing that I was looking forward to in going was the chance to really explore political theory. I had been a political science student as an undergrad, but I didn't feel like I had yet fully mastered that subject. I knew I wanted to go to law school eventually, so it wasn't, in a sense, a kind of necessary professional degree. It was just the thing that I wanted to do to enrich my own mind. And it was certainly all of that, in addition to just a wonderful experience personally, and an opportunity to grow and see a lot more of the world and travel, meet people from around the world. So it was very fulfilling on both of those levels.
Right. You also met the woman who would go on to be your wife, Mary, during the time that you were a Rhodes Scholar, and she was a scholar from Canada in your year. Can you tell us a little, if you don't mind, about how that happened?
Yes, that's actually kind of a funny story. My very good friend, Brian Rolfus, and I were having drinks at the King's Arms one evening, and it was about closing time. And as we were getting ready to leave, he said to me, I signed up to go tomorrow to welcome the incoming scholars, And, I'm just really feeling anxious because I'm trying to study for my qualifying exams. And he knew that my degree did not have qualifying exams, so that I was not under that particular pressure. And so he asked if I would go in his place. And only after I said yes, that I would go to meet the incoming scholars, did he inform me that the bus was leaving for Heathrow at 4 a.m. in the morning. So, so I got up early and I went and met the plane, and there were two planes coming from North America on that day, and Mary was in the first of those. And so we sat and had tea and chatted with a few others while we waited for the next plane. And that was sort of the start of that relationship. So we met in Heathrow Airport.
Right. Also, sort of, this is a slightly deeper question, perhaps. What did you regard as your mandate to be when you went down as a Rhodes Scholar in 1991, if anything? And how has that informed the work that you've done ever since?
Well, I think my mandate, in a sense, was not much different from what I felt it was when I went up to Oxford. I always was interested in pursuing a degree and profession in the law. I always felt called to the area where law and politics or government intersect. And I wanted to do that. I guess what I felt was I had this great opportunity to enrich my thinking about those things, and perhaps to launch off even better suited for that goal. So I kind of redoubled my intent to do that, and ultimately have been able to do that in my career. So I'm very grateful for that.
Yeah. Also, another question that I had about this is a lot of, in my experience and in the conversations that I have had with other Rhodes Scholars, a lot of them experience, when they come to Oxford, feelings of guilt about, not just about sort of being part of Cecil Rhodes's controversial legacy, but also because they think that they are the undeserving recipients of the privilege and social capital that comes with being a Rhodes Scholar. And that's something that kind of gnaws at them a great deal. Is that something that you struggled with as well? Or, and if you did, how did you grapple with it? Or was it not something that you had to deal with?
I think I've been fortunate that I've not experienced the kind of guilt that many of my Catholic and Jewish friends do, perhaps because of their upbringings. It's not a big feature of my psyche. And no, I don't think I ever felt guilt. I mean, I think what I felt was inspiration. I had a wonderful opportunity. For me, I think that I presume that one of the reasons, I presume one of the reasons that the Rhodes Committee had selected me was because they appreciated the drive that I already had to fight the world's fight, in the sense of contributing to making the world a better place. And so, I think I kind of felt that I needed to double down on that, but it wasn't out of guilt. It was because that's who I was. And now I had this even greater opportunity.
External validation of that as well. And my last question then about your Rhodes journey is, you also, a lot of your friends at the time, when you were in Oxford, especially, Rhodes Scholars in particular among them, came out as LGBTQI. And in recent years, you have made the cause of ensuring equality for LGBTQI people your own. through the litigation route, at least. And would you say that that exposure was what set you on the path to doing the work that you now do?
I do think that experience, my friendship with those individuals significantly affected my approach to LGBTQ issues, and deepened my interest in it, and made their call to justice and equality, something that was very personal to me.
Yeah.
And so, yes, I think it did have an effect on me in that sense. Brian Rolfus, the one I mentioned, who sort of was the reason for my going to Heathrow and meeting my wife, he ended up in my wedding as one of my groomsmen. By that time, he was one of those friends who had come out as gay. And when my wife and I wrote our wedding service, we did so with a specific attention to making sure that it was the words we were using were words that could be used by a same-sex couple as well as an opposite-sex couple. And we took each other as partners in life, and we were very intentional about that. So yes, knowing them, knowing of their struggles, and knowing of what wonderful people they were, their humanity, and that they wanted the same thing out of life that we wanted, has made me much more focused on their call for equal justice.
Right. After your time at Oxford, you went on to pursue law. You pursued the JD at Harvard Law School. In addition to the substantive legal education that you acquired there, were there any non-obvious insights about the law that this period taught you, which you can share with us?
Well, I think that I, at law school, continued to approach law in terms of focusing on the intersection between law and government and politics, and how law is used to organize society and to resolve disputes. And one of the things that I did while at law school was I was a teaching assistant for a course at Harvard College taught by Michael Sandel called Justice, which is a pretty high aspiring title for a course. And it is in fact very enlightening, challenging class, and I really enjoyed the experience teaching. In fact, one of the things I can proudly say is that 2 of my very small section of students went on to win Rhodes scholarships themselves. Cool. And those conversations were just so wonderful in exploring how the political theory and philosophy mapped onto and informed our discussion of claims of rights and legal disputes. Many of the issues that we grappled with in the course were actually kind of live legal questions that were being addressed in the courts as well. And so I think that I've taken that approach and the benefit of that way of thinking to my practice as well.
Right. You were also the supervising editor of the Harvard Law Review during your time at HLS. I have 2 questions about this. One, if there are any insights that you acquired from this experience that you can share with us generally, and then a very specific question, which is that a lot of people find legal scholarship, this may be at a high level of generality, but a lot of them find legal scholarship to be quite abstract, to be quite abstruse and unhelpful. Chief Justice Roberts, for example, commented about this in 2011 at a speech that he gave at a judicial conference, where he said, pick up a copy of any law review, and the first article that you are likely to see is on how Immanuel Kant has influenced sort of theory approaches to evidence in Bulgaria in the 18th century. And he sort of said that if that is the level of abstraction at which legal academics want to talk about issues, that's great and that's their business, but that they should not then expect what they write to be of help or of any interest to members of the bar or the judiciary. Now, of course, he was perhaps overstating the case because he himself relies on law review articles in his opinions from time to time. But my general question is, to what extent are concerns about the myopia of legal academia well-founded?
I have to say that I'm somewhat sympathetic with the Chief Justice on that view. My experience on the Harvard Law Review was wonderful in the sense of the community of colleagues that I worked with who were quite wonderful, and it kind of made a big school smaller in that way for me. But it also was important because it made very clear to me that I did not want to become a legal academic, which I kind of thought I might when I went to law school, because I had a similar reaction to the Chief Justice to the academic writings that we were reviewing and publishing in the Law Review. That they seemed very disconnected to the practical concerns of the law and of people who are struggling with the law and trying to change it. And so I've always had a much more practical bent than that, and find most of legal writing in academia these days to be pretty far removed from that. At one point, when I was leaving the Department of Justice later in my career, I kind of toyed for a short minute of going back to academia. And when I talked about it with a law school professor friend of mine, and he sort of asked me, well, what would you be interested in writing? And I gave him a few ideas, and he said, oh, no, that's far too doctrinaire, doctrinal rather, not doctrinaire, doctrinal for law school. And I said, well, what do you mean by doctrinal? And he said, too focused on what courts are doing and the law and the courts. And I said, you mean of practical relevance to actual lawyers and the people living under the law? And he goes, yeah, I guess maybe. So that wasn't for me. As I said before, I'm far too focused on the practical effect of the law.
Right. That's very interesting, and that sort of maps onto my own thinking on the subject as well. But I do want to ask you this follow-up. So I put this question to Professor Tarunab Khetan, who teaches law at the University of Oxford, is a Rhodes Scholar himself, and he was the first interviewee in this series. And his answer to the question was that we should not demand practical utility from academics because we do not know. First of all, it might take us down an undesirable path if society starts placing demands on academics in this way. And then secondly, also because it's not very easy to determine what is or is not a practical utility, because it may become useful down the line. And therefore, he sort of pushed back against the notion that academics should engage in more practically focused writing. How would you respond to that?
I'm certainly not one who would try to put limits on what academics can research or write. I'm a fervent defender of the First Amendment in that sense in the United States.
Yes.
But I think it's a different question why law students would necessarily pay top dollar for that. If I think what they want is an education that trains them to be good and effective lawyers. And so as long as the professors can continue to provide that, if they want in addition to be thinking some broader thoughts, more foundational questions, is totally fine. But you know, at some level, law and students who study law are doing it because of the practical utility of the field, and they want to understand how to approach it, how to dissect knotty problems, how to make effective arguments, and advocate and represent their clients well. And so I think the law schools need to focus on doing that and preparing them to be the best lawyers they can be in their careers.
Right. My next question to you is about your time in the Justice Department, and particularly when you were the assistant to the Solicitor General between 2004 and 2009, as I mentioned in the introduction. And the questions that I have about this is, first of all, are there any cases that you argued or did during this period that particularly stood out to you? And then secondly, to what extent did you enjoy autonomy in crafting legal arguments in the cases that you were assigned to work on? And to what extent were the arguments you made shaped by the White House, your superiors, or other elements in the executive?
Well, I think that when one enters the Justice Department, you do so, you make a deal, if you will, with yourself and with the government, that you put aside your own political views in favor of representing the executive branch of the United States. We love to stand up and say on behalf of the United States, and I still think, I mean, that was a real thrill. But the fact is, you're representing a particular branch of the United States federal government. You're representing the executive. And the arguments that you're making are arguments about the institutional interest of the executive branch. And as long as you are kind of focused on that, then I think you can understand why and how you would defend a policy that may not be your preferred policy, but instead you're defending the process by which the policy was made and the right of the elected representative to make that policy, because elections do matter, right, in a democratic system. And you know, that was how I made my peace when occasionally I had to defend a policy that was not my own preferred one. I never felt like I was making an argument that was not well grounded in the law, and wasn't one that was, to a large extent, the same argument about process, deference, the balance of power, separation of powers between the branches and between the federal government and the states, that would be made regardless of which party held the presidency. So I think that if you approach it that way, for the most part, you can feel good about your service to the department and to the public, you know, under any administration.
Right. And then, were there any particular cases that stood out to you that you worked on that you can share with us?
So one of the things that I did, I represented the State Department in many cases, including some fairly high-profile cases. The State Department was a wonderful client. They were extremely thoughtful. They were the sort of the epitome of wonderful public servants. They had the long view of the United States interest in the world at heart. It did sometimes put us, you know, on the opposite side of some very sympathetic, you know, parties on, you know, like plaintiffs. There was one case in particular that stands out where the state of California had created a law or passed a law that created a cause of action for individuals who had suffered forced labor by our enemies in World War II. And so some claimants under this law had been, victims of forced labor in concentration camps in Nazi Germany. Others had been U.S. servicemen who suffered forced labor under the Japanese in the Asian theater. And I remember as I walked into a courtroom, a U.S. veteran who had served in the Philippines handed me a note that said, "Why are you opposing us?" That was, very emotional. But at the same time, the principle that we were arguing for was that, the foreign affairs power in the United States is committed to the federal government. The states don't get to make their own 50 different foreign policies. We have one foreign policy for the United States. And the foreign policy of the United States at the end of World War II had been to try to help Japan's redevelopment as a democratic nation and not to burden it with mounds and mountains of liability for the wrongs of the former imperial regime. And so, we were making an argument that, yes, was opposed to the ability of these individuals to recover damages against Japan or Japanese corporations, some 50 years later. But at the same time was about advancing an important principle of the separation of powers and federalism. And so, that was kind of it was both a very poignant moment because it was very real that there are individuals who were impacted by this, but at the same time, it was an important legal principle that we were arguing over.
Right. My next question to you is about, so you have been, you are, as I mentioned earlier, a seasoned appellate litigator, and you've argued 17 cases before the Supreme Court. The Supreme Court in 2018 was involved in a massive controversy concerning then Judge Kavanaugh's confirmation to the Supreme Court. And I'm referring here, of course, to the allegations that were leveled by Dr. Christine Blasey Ford. And eventually, of course, he did get confirmed and is now a justice on the Supreme Court. Dahlia Lithwick wrote an article at the time, which was titled, just give me a moment here. 1 year after Kavanaugh, I cannot go back to SCOTUS. And in that article, she basically made the point that there is a temptation to normalize the unprecedented seating of someone who, subverted the very truth-seeking and inquiries that justice is supposed to demand, and also kind of spoke about how Brett Kavanaugh, by virtue of his power, now has monopoly on normalization, on letting bygones be bygones, and on turning the page. So my question to you is this. Many people might argue that justice is an indivisible concept, and that therefore, by participating in the functioning of an institution that has been involved and is involved in this form of wrongdoing, you are in some sense complicit in that. So is that something that makes you uncomfortable or that you think about?
Well, I don't feel myself complicit in any injustice. I think, again, going back to my pragmatic streak that we've referenced before, the court is the court. It has the power it has, and we have to continue to make arguments to it to try to shape the law in the way we believe is best and promotes us as a society. I do share a fair amount of frustration with the extent to which the current court has become politicized. I thought that the refusal to give a hearing to Merrick Garland when he was nominated by President Obama was just a blatant politicization of the court, and really marked a turning point, unfortunately, for the court as an institution. And I think it needs to be very, very careful about that. But I served under Justice Kagan when she was the Solicitor General of the United States. I have great respect for her. And I see in her and the way that she continues to operate within the court, working to try to bring along majorities for the positions that she thinks are right. And I think that's an inspiration about how to deal with this. It's I can appreciate the sentiment behind Dahlia's article. But I would suggest that kind of giving up hope and writing off an institution as important as the Supreme Court is kind of self-defeating. We need to continue to work with it. We need to continue to make the arguments and demand of it that it be the institution that it's designed to be under our constitutional system. Rahul, I think that you've been muted, perhaps unintentionally.
Hi, I'm sorry, there was a technical disturbance. So I heard you up to the point that you were talking about Justice Kagan and how you seek inspiration and how she conducts herself.
Yes, that's right. I think that she shows us that we need to continue to work with the Supreme Court as an institution. It's just too important to write off in any respect.
Right. My next question to you is about the Obergefell case, which you argued, and the how much that case meant to you personally, I think, is best evidenced by the fact that you recited a poem by Edwin Markham called Outwitted when you appeared on Dahlia Lithwick's show after the oral argument to sort of make the point that the circle of marriage should cover within its ambit same-sex couples as well. Can you tell us why it is that case mattered so much to you?
It's funny because I go back to some of the themes that we were talking about earlier, that notion that I grappled with in college, Robert Bella's theory of the critical reappropriation of tradition. I am in many ways a real traditionalist. My own marriage has been, to me, foundational to my life and to that of my family, and I think that it really is an institution that allows for fuller human fulfillment, and so I'm really committed to this institution of marriage, and I could not imagine how we could deny LGBTQ individuals the same right to experience that and to find fulfillment within that institution if they chose. Of course, it's not mandatory. Nobody has to choose that institution, but to deny them the opportunity to share in that was, I thought, wrong. And so it grows out of both my sense of commitment to these traditional institutions, but also to how we have to understand what's truly fundamental about them, and then apply that learning to our new reality. Right. One of the things that I was struck by as I really got into the marriage case and getting ready for argument and thinking about it was how the cases in the United States that had occurred in the 1970s up into the early 1980s, and these were many of them cases that Justice Ginsburg herself litigated when she was with the ACLU, to establish that women were of equal status within the institution of marriage. First, that women were of equal status under the law, and then specifically with respect to marriage, that marriage was not, as a constitutional matter, could not be an institution of hierarchy, male and female, where the law separated these roles by gender and said the man is the head of the household, the woman is in some sense legally subservient to him. Through the course of those cases, and by the end of it, it established that as a constitutional principle, marriage, even though it's governed by state law, as a federal constitutional matter, marriage is an institution of two equal spouses. Their rights and responsibilities in marriage are identical one to the other, regardless of their gender. And it's really only after you've changed the institution of marriage from one of hierarchy to one of a partnership of equals that you can actually ask that question about now, well, why can't it be two men, or why can't it be two women? Because it's spouse and spouse. And so what I resisted was the notion that you had to kind of transport yourself back to the 1860s when the 14th Amendment's Equal Protection Clause was written to say, well, would they have thought, marriage included two men or two women? No, but neither would they have thought that marriage was an institution of equals, right? So we have to reevaluate that institution in light of that new reality.
Right. So then I have two follow-ups on this. One is that, as lawyers, we are often asked to cultivate objectivity and detachment in terms of dealing with the cases that come before us. And yet, there are some cases, as is clear by the example of the Obergefell case for you, which do mean, which lawyers feel personally invested in as well. So how do you balance those two conflicting impulses? And then the second question is, the phenomenon of how the US Supreme Court moved from Bowers versus Hardwick in 1986, in which it upheld the criminalization of sodomy, to Obergefell, is a much studied phenomenon. What is your own estimation of how this seismic shift sort of came to be? What was it that brought it about?
Right. So I'll take the first of those questions first. I do think that the law, certainly in the Supreme Court, the court is interested in the legal principles far more than the specific facts of the case, right? Because they're only going to take one case to decide the legal question, and then that will govern all of the other cases. So they don't really want to hear a lot of detail about the individual parties. Yet, in that case of Obergefell, highlighting the specific lives and the impact of these laws on our individual plaintiffs was, I felt, critical. And in the rebuttal, which was, I opened my argument, then the state of Tennessee's lawyer spoke, and then I had 5 minutes at the end as rebuttal. And I think by that time, because we were the second argument and it was the end of it, the justices were kind of tired and they kind of just let me speak, which is unusual in the Supreme Court. But I was able to talk about our individual clients, not in the essay, and not just too much about them, but to use them as examples of legal points. But the ultimate impact I was looking for was to stress that our clients in Tennessee were already married. They had married in New York, or they had married in California, and then they had moved for one or another job-related reason to Tennessee. And Tennessee was saying, well, the cost of your moving here to take your job is that your marriage is no longer recognized. You're no longer a married person. Your family ceases to exist. And so what we were trying to establish in using their individual stories, which were so compelling to impress on the justices, was that their marriages were every bit as much foundational to them and their lives as any of the justices' marriages. And I think in reading the opinion that Justice Kennedy wrote, that is the impact of the argument on him. That I read the opinion and I think of it as a love letter to his wife. It's about how fundamental his marriage has been to his own life. And he couldn't see denying these couples that right as well. And so you do have to think about, how do I take the story of the party that I'm representing, and within the broader themes of the law, tell that narrative in a compelling way and use it to illustrate the points that I'm trying to make. So that's sort of the answer to the first question. In terms of the second, I think it's related. How did we get from Bowers to Obergefell so quickly? In some ways, the court, although it is not a political body, it shouldn't be a political body. It doesn't sway from one side to the other based upon the most recent poll. It is a creature of society. The justices are themselves members of society and influenced by it. And I think I have no doubt that shift has a lot to do with the fact that over that time, probably many of their own friends, family, acquaintances came out, and gays and lesbians became not some kind of mythic thing in dark alleys and bars that had closed windows, but instead their neighbors and friends, and they understood them as humans with the full range of human emotions and virtues and vices, and that humanizing effect of really the effect of the AIDS epidemic, and the fact that gays and lesbians were coming out of the closet was hugely impactful.
Right. The fight for LGBT equality is currently underway in many jurisdictions. So, for example, in India, the Supreme Court in 2018 decriminalized homosexual intercourse, while on the other hand, in Singapore, the High Court in March upheld a law criminalizing homosexual intercourse. So, in your opinion, what are the factors that unite these struggles, and what might help explain the differing outcomes that we are seeing?
Well, I think the fact underlying the struggles is, it's a universal claim to equal dignity. That's the word that Justice Kennedy used so frequently in the LGBTQ decisions that he authored, and that I think is universal. So it's not surprising at all to see the claim to equality, to equal dignity being made in all of these jurisdictions. Of course, not every jurisdiction is as open to change as others are. And, I think, in Singapore certainly is one of those who is a society that has a greater tradition of more top-down, authority and decision-making, and much less of an individual rights up kind of notion of government. And so it's not entirely surprising to me that as yet we haven't seen that struggle succeed in Singapore. But I have full confidence that within the span of my lifetime even, it will be universal, because I think that this is a tide there's no turning back on. Once you've recognized somebody's humanity, you can't go back from that. And see it in some societies and other societies that continue to deny it. Eventually, they're just exposed both unjust and fraudulent. So we'll get there, although it's frustrating how slow it is in some jurisdictions.
Yeah. Another question that I had on the LGBT sort of work that you've done is that in addition to the Obergefell case, you've also argued the case on parental rights before the Supreme Court, as I mentioned in the introduction, and you've argued on behalf of LGBT students, employees, etc., as well as under the Affordable Care Act. So, are there any insights from these battles that you can share with us? And also, sort of one emerging hot button issue in the fight for equality for LGBT individuals has been the issue of how their rights can be balanced with the religious freedoms of others who say that upholding these rights will undermine their religious beliefs. And my question to you is, in your assessment, how can courts balance those conflicting interests? Is it just by making sure that they provide conscientious objectors the elbow room not to participate in proceedings that violate their rights or their freedoms, religious beliefs, or is there any other way that you've thought of in which this can be done?
Well, I confess that I approach this with a healthy respect for pluralism. In a diverse society, I think that respect for others and our differences is the only way that we can hope to survive and thrive together. And so I think that we do have to make accommodations both ways. But what I find troubling and to some extent frightening is the current assertion by the certain religious elements of a right to be free from any law with which they disagree, including anti-discrimination laws. I think that that's a recipe for chaos, where everybody becomes their own legislator. I don't think that a society can function that way. But I also think that it's self-defeating. I firmly believe in the protections of anti-discrimination law against discrimination on the basis of religion. But if one has a religious right to discriminate, then that protection from religious discrimination is empty, because everyone can always rephrase religious discrimination as my religious right not to interact with someone of a religion that I disagree with. And so I think that it's very short-sighted for these religious elements to be making the argument, because I think they will later rue the day that they did if they end up undermining the protections of these anti-discrimination laws.
Right. I see that our original time is about to end, but if you do not mind overstaying a little bit, I would like to ask you a couple of final questions about oral advocacy, given what a fine sort of litigator you are. Would that be fine by you?
I would be happy to talk for a few more minutes.
Okay, that's excellent. So one question that I have, perhaps the second last we can take this as, is, in your opinion, what is it that goes into the making of legal arguments that cannot be persuasively countered by one's adversary?
Well, I think that very often legal argument is about what is the proper framework to adopt from which a court should view a particular dispute, right? So I remember one case is a good example of this. It was a case about whether the federal attorney general could rescind the drug dispensing licenses of doctors who were prescribing drugs for the purposes of assisted suicide under a law in Oregon that allowed that. And as it went to the Supreme Court, I was with the Justice Department at the time, and my job was to defend the policy of the Attorney General, although it was not my own. And we were arguing for a framework that was looking at this from the perspective of there was a federal law that said that doctors were licensed to prescribe these medicine consistent with good medical practice. And so that was a term of a federal law that applied across the nation equally. And the Attorney General said, I am responsible to administer this law. I have to give meaning to that phrase consistent with good legal medical practice. And I reasonably mean not killing one's patient. That is, in fact, you know, a view of the historic Hippocratic Oath. Since there is a single federal law and I have to, I'm charged with it, implementing it, and it has to have a meaning. I can't really duck from giving this phrase a meaning. So that was the framework that we tried to give to the case and offered to the court for how it should be looking at the question. The other side, Oregon, was, by contrast, giving a very different framework. They were saying, you know, we have a history of regulation of the practice of medicine by the states. And so when this phrase appears there, the good practice of medicine, it means medicine as regulated by the states, because that's the historic backdrop against which it's written in. And they were bringing in that notion of kind of federalism, where the federal government regulates certain things like interstate commerce, and the states regulate primarily other things such as the practice of medicine. And, you know, so it wasn't so much that we were arguing point and counterpoint about little specific things. It was more trying to frame the right way to look at the question. And, you know, ultimately, Oregon won that fight. I personally think that probably was the right outcome in that case, not just because of the policy, but because of that history of respect for state regulation of medicine. And I didn't think that the Attorney General probably was the person in the federal government that would have been granted the role of you know, deciding what good medicine was, since he had no medical training whatsoever. But that's sort of how I think the practice of argument, brief writing, framing of your case, it happens. That you're writing a narrative, but then it's a particular kind of narrative. It's a narrative against the backdrop of these themes in the law and legal principles, and you're trying to come up with a narrative that has greater explanatory power of these legal principles and kind of foundational concepts in the law. And I mean, that's why I enjoy what I do. I find that I think it's fun. I enjoy the battle of wits with opposing counsel trying to each do that better. But the other thing that I would add, and it goes back to something we were talking about earlier, is that at the end of the day, I think that a good lawyer always listens to their client. My client comes to me because my client has a problem. Something is going wrong. And I have to listen to them and understand what they think is going wrong. They may not have the words to put that into a legal cause of action or a legal theory. That's my job, right? But I have to listen to them in terms of what's the real problem, what's their real claim to justice in small j, and then use that to craft a theme around it.
Right. Right. And then, okay. And then my last question to you is on, so it may sometimes be that in the cases that you argue, the court, some justices or judges, if it is not the Supreme Court, may have a predisposed mindset in terms of how they are going to rule. So, to an outsider, the US Supreme Court does appear to be split on liberal conservative lines on a lot of these sort of social issues like marriage equality. So, for example, in a case like Obergefell, when it is clear that the conservative wing of the court is unlikely to rule in your favor, do you get disheartened by that, or do you try to derive satisfaction from having done the best that you can in terms of making the most persuasive argument that you are able to craft?
Well, I think ultimately one can't control the justices. And so at the end of the day, one has to do the best that you can, and then be satisfied with that and let the chips fall where they may, as the saying goes. But I do think that, in the Supreme Court is a special circumstance, because these are 9 justices that we get to know pretty well. They are the same justices over and over again. They write a lot of opinions, and you have a good sense of who they are. And the challenge there is to craft an opinion that is most likely to appeal to a majority of them, right? The most important qualification for a Supreme Court advocate is the ability to count to 5, because you need 5 justices. You don't need 6 or 7, 8. That would be lovely, but 5, that's what you need, right? And so you have to, what you have to do is, even if, especially if you're trying to put together a sort of a group of maybe even ideologically disparate justices together for a coalition in a particular case, you have to think, okay, I'm going to make this argument this way because it will appeal to that justice, but I can't go over here because that would offend and maybe scare away that justice. And you have to craft the argument in a way that is most likely to get you to 5. And so, in the Obergefell case, we did that to the extent that we decided to make our primary argument about the right to marry, and that fundamental right to the dignity of being able to marry and establish one's family, rather than emphasizing primarily the equal protection argument about non-discrimination against LGBTQ individuals. Justice Kennedy had had a chance before to write a major decision about equal protection and anti-discrimination against LGBTQ persons. He had never done that, right? So we crafted our argument to appeal to him as our 5th vote.
Yeah. Right. Okay. Thank you so much for those wholesome, thoughtful, and comprehensive answers. It's been an honor to speak with you, and I have learned a great deal from our conversation, and I'm sure many others will as well when they listen to it. So thank you so much for taking time out. It's been a great joy to talk to you.
Rahul, it's been a great pleasure to talk with you as well, and I hope you stay safe, and I hope that you continue to fight the world's fight in your own way.
Yes. Thank you. I hope so too. Amen. Yes.
Take care.
All right. Yes.